I've been 10 years on this court and 22 years at like deciding cases, and I want to do something else. And it's not that I don't like the court. At this point in time, on this court, there is so much respect and so much energy, but after 10 years, it's time for me to do something else. And I want to find other ways to contribute to society. And this one area that I have not explored enough, in my view, is through education. And I've been associate professor at University of Sherbrooke since 2006, but I also contributed to the work of other universities. So I want to get closer to universities. But there are also other levels of education that I think should not be forgotten, and where there is effort and energy that can be devoted, and it's below university. Not, I shouldn't say below, but like college and high school students, because one area where I would like to spend more energy is all the area concerning ethics and professionalism. And I think the seeds of ethics and professionalism has to be put in the ground early. I get the feeling that we live more and more in a society where people look at themselves. En français, on dirait les gens se regardent le nombril. Or another way to put it, we live in a society where the rights are now mostly focused on individual rights, but be it our charter or be it just the life in society in general, we have to look at the best interest of society, not only the best interest of one individual in particular. So through ethics, I think one message that can be conveyed is that yes, individual rights have to be protected and safeguarded, but life in society is important, and respect for the other person's right and for the rights of for the like realizing that life in society implies that there will be constraints. Certainly, in many cases, I've been concerned that the rights of society are not given sufficient importance, but always, I'm always also concerned that individuals are treated fairly. For example, in criminal law, I may be more concerned with the right of society and the search for truth, but I will make no compromise, for example, on the reliability of evidence. In my view, the basic foundation of our criminal law is that the evidence has to be reliable. So I'm not in for wrongful conviction. I think it's one of the worst problems that could happen if there is a wrongful conviction. So for me, reliability is one of the areas where criminal law cannot suffer any compromise. On the other hand, it's true that in the cases that I wrote in criminal law, and in criminal law I've mostly written in dissent, and that shows my concern for the need for society to be a workable place. A place where everyone has its place, not only the individual. So, in the individual that is persecuted, yes, but also we have to take care that we live in a peaceful and just society, and that means having at heart the need to look for the truth. Ten years ago I came here, I thought that I was fluently bilingual, and you might remember I spoke to you in English, obviously. But when I realized that I had to convey the very small nuances of my thoughts, that I could not convince, or I didn't think that I was able to really get as deep as I thought I wanted, in order to convince my colleagues. Then I thought that I needed to understand more about the process, and then I think my English improved at the same time as my level of understanding of the workings of the court. So all this explains to you that the process in this court comes one case at a time. So you get to know your colleagues, you get, in my case, I got to master a little bit more the language, and then I got to know more also in depth of why this result, or why this judge took that position in that case. So it's one case after the other where you get to know your colleagues. Our first public, if we want our views to prevail, our first public is our colleagues. And that's why I mentioned earlier that it's very important to be able to convey your ideas very clearly. And it's in those circumstances that your talents as litigator, as former advocate, are very important. It makes the life of a judge a little more difficult when the judge is not 100% comfortable in the other language. It put me at a certain disadvantage when I wanted to convey my ideas to my colleague, but in the end, I don't think it affected the result, because it took more time, sometimes I had to write memo, but the idea ended up being formulated, stated.
What do you think, though, on this notion that everyone should be functionally bilingual when they get up here?
I'd say it makes life easier.
Can you do your job better because of it? I mean, you can think, you understand.
Doing a job better, I don't think that the result will be affected, but I think that it's easier, let's say. What was the most challenging for me in this work is to achieve majority in the case where I thought that it was preferable, or I was more comfortable if I was the one to write the case. And in order to achieve majority, you always have to integrate the colleague's idea. So integrating colleagues' idea means often means narrowing your reasons. in order to keep the focus on the reasoning that you want to apply in other cases without embarking on cases that don't need to be resolved immediately. And so integrating colleagues' idea in a way that satisfies them and that saves some comfort for the writer, me in those circumstances, is the most challenging part of our work. I'd say the most rewarding comes with it. It's when you succeed. And when you don't succeed, very often you will only know about it at the end, when there are floating voices and the concurrence will come in, not in favor of the reasons that you will have circulated, and you don't always know why. So this is the difficult part. But the rewarding part is when you are able to do that and in a way that brings comfort to you for the sake of the rule that will be applied in the future. On the other hand, when you know from the outset that you will not be in the majority, and very often you will be the lonely dissent, then you have no constraint. So you don't have to write narrowly in order to bring other people, but obviously you want to keep the focus on what the case is about. But very often, yes indeed, I've found myself in minority. And that's what life on the court is. It's collegial, but it's also, under our system, we have the right to voice our dissent. Very much as my predecessor, Claire Leroux-Dubé, I think that very often the dissenting reasons or the concurring reasons are ways for the law to evolve. Litigators in other cases may find some of the ideas can be used in other contexts, and then these ideas or these reasoning can prevail, and then this is a way for the law to evolve. I'm happy to have participated, to have contributed to the work of the court. And my jurisprudence might be used as a springboard for the development of the law, and I will be very happy if that happens. With the number of dissents that I wrote, it's likely to happen that way more than through my majority judgments. My majority judgments are really the work of the institution. So I think the institution is what counts, not the individual judges.